today's webinar.
Okay, thanks Richard. Hi everyone, nice to see so many familiar faces on here. It's a different time for me this morning. I'm normally lunchtime, so
Yes.
I've had 2 coffees. Bruce will be speaking at the speed of light at this rate, a couple of espressos down him. Anyway, I just want to introduce Bruce Frew from St Philip's Chambers. Bruce is going to talk us through TUPE today, and we sort of build it as TUPE the basics, and there's going to be a secondary webinar on sticky issues or something to that effect with regard to TUPE. So this is sort of a whistle-stop overview. You will get the slides at the end, and also there's a handout that Bruce has prepared, which Richard has kindly uploaded as an Adobe document, which you can have a read through in your own time. And so without further ado, I'll hand over to Bruce. And if you do have any questions, please do put them in the chat box, and we'll either take them as we go, or we'll take them at the end. Okay, over to you, Bruce.
Thank you. Well, morning, everybody. This is a fairly new format for me. I have done a couple of these before. And by way of introduction, my name is Bruce Frew, as I've kindly been introduced already. I'm a member of a team of 28 employment barristers where we only specialise in employment law. And TUPE comes up with us quite a lot. Now, given that this is an overview, what I'm going to suggest is that any of the sticky issues that Maria's referred to earlier could be recorded. So I would, in short, what I'm saying is use the free services of a barrister. Certainly I'll be able to answer anything today, if at all possible, if there's enough time. My email address is at the end of the pamphlet that you're going to receive in due course, and I'm very happy for you to contact me by email. But also my colleague, Paul Wilson, is going to do the second webinar on this, where more specific details will be dealt with, which will be very helpful as well, as helpful as this will be, I hope. Now, I've got to say that in my role, I do a number of talks and seminars, but it's done in a very formal way, I suppose. And it's a breath of fresh air, actually, to be talking about the weather and to be doing it in a fairly informal way. And I think that we'll probably learn more from the informal approach. Now, on that basis, I've been given a fairly dry subject to talk to you about, but it's very, very important, of course. And I've been asked to spice it up a little, and that's fairly difficult, I've got to say. And when I've considered TUPE in the past, it's been described to me, and this may be an age-inappropriate example, because it dawned on me then when I was speaking to some of my colleagues in Chambers that they'd never heard of Wurzel Gummidge. For those who don't know, Wurzel Gummidge was a character, I think from the 70s or 80s on children's television. He was a scarecrow and he used to change his head. And TUPE can be described very much as a Wurzel Gummidge situation amongst the older of us, it is, where the head changes but the body remains the same. And that's something that I always consider, remarkably actually, as soon as the problem comes to me. So, as I say, this is a webinar that provides an overview of the main provisions of TUPE. It does consider the situations where TUPE will apply, and it addresses the main principles and obligations arising from TUPE, including the automatic transfer principle and obligations to inform and consult. What I've got to say is there's an overview of TUPE that doesn't really allude to the fact that TUPE is just an absolute labyrinth. It's quite a tricky area of law to deal with. I would urge you to ask any specific questions because they need very, very specific advice, in my experience. A broad brush is quite difficult, but this will give you a flavour of it in any event. The background to TUPE is largely the reason why it's a labyrinth. Comes from Europe, where we've got a question mark over that, and some of you may have a question as to whether or not the fact that we're no longer going to remain in Europe, what will happen to European-based legislation. The best answer I can give, apart from I've absolutely no idea, because I don't think Britain has any idea, is that this law is so far entrenched into our system that it won't go. It may alter, but it's only just altered as recently as 2014. So, the background to TUPE is that it came into force on the 6th of April 2006, replacing the same legislation from 1981. It applies to any relevant transfer that took place on or after the 6th of April 2006. It implements the Acquired Rights Directive, where currently English courts and employment tribunals, probably more importantly employment tribunals for the purpose of our talk, are required to give TUPE a purposive construction to give effect to the general purpose of the underlying directive, which is to safeguard employees' rights on the transfer of a business. Now, what that means is that it stems from Europe and we have our own interpretation of it. Now, what it did is introduce three concepts into UK employment law. That is the automatic transfer principle, where employees transfer to the transferee, who inherits all the rights, liabilities and obligations in relation to them. There's a protection against dismissal in connection with a TUPE transfer and the obligation to inform and consult with representatives of the affected employees. It applies to all of the United Kingdom with exceptions in regard to Northern Ireland. There's a part of both the slide and the note, which is a repetition of the slide, which identifies the position in Northern Ireland. It would be interesting to know if there is anybody listening in from Northern Ireland. And again, you may have some specific questions in order to identify the application of TUPE in Northern Ireland specifically. The changes in 2014 to TUPE are of crucial importance, I think. There are various changes to TUPE that have been made. The amending legislation is referred to as the Collective Redundancies and Transfer of Undertakings Regulations 2014, came into force on the 31st of January 2014, and that's subject, as they always are actually, to transitional and saving provisions. Key question then, when does TUPE apply? Because what I find in reality is that people are scared to death of TUPE, and as soon as they have a change of the Wurzel Gummidge style head, there's a presumption that TUPE does apply, and they start worrying about what you've got to meet in order to satisfy TUPE. TUPE applies to a relevant transfer, which means either or both of the following. That is, a transfer of a business, undertaking or part of a business or undertaking where there is a transfer of an economic entity that retains its identity. That's a business transfer. And that involves three elements: an economic entity, transfer of that economic entity, and the economic entity retaining its identity following the transfer. That's often referred to as the going concern test. Again, there's a huge amount of law in regard and case law in regard to the going concern test, which would need specific advice, I would suggest. Whether or not it's an economic entity is a question of fact, so don't presume that it is. And what you must bear in mind, whether you're transfer or transferee, is that at this stage, this is where the importance of lawyers or HR experts come into place with the drafting and negotiating of employment indemnities and warranties. That is, of course, an indemnity or a warranty that the liability that flows from the transfer is perhaps dealt with only by one party. That's the saving grace often when it comes to tribunal, or even the very start of tribunal, so that you can be excluded as a party. And so terribly important and often missed. So a little bit of detail: a client engaging a contractor to do work on its behalf, reassigning such a contract, or bringing the work in-house, that's a service provision change. This can encompass an initial or a first generation outsourcing, a subsequent or second generation outsourcing, or an insourcing. And to put that into a more friendly example, cleaning companies are susceptible to this type of change where, for example, a local authority will outsource a cleaning contract of a particular part of them to a cleaning company, contractors. They tender for it, another one comes along. There may be a string of cleaning companies dealing with this particular building that's being cleaned, and then eventually the local authority bring it back in-house. these are transfers which come under the umbrella of the service provision change. What's enormously important is that the supply of goods or a one-off buying in service is excluded. I dealt with a case where my opponent, and this was at the Employment Tribunal in Sheffield a couple of years ago, my opponent had a brilliant TUPE case, save for the fact that TUPE didn't apply because his client was providing widgets into an engineering process. And they just would not accept that the provision of these widgets was the supply of goods. And under that set of facts, TUPE simply didn't apply. And it got to the very last day of the tribunal where the judge had to emphasise, in actual fact, that TUPE didn't apply. So it's these types of things where, of course, it's always a question of fact. A great deal of consideration should be given, because you can miss a lot of liability by not having that attached, or save embarrassment in the tribunal if, for example, you are representing claimants.
So sorry, Bruce, but the most common examples that I come across in practice are either business, so the business sales, so the transfer of a business as a going concern. So if you think about it in sort of more basic terms, it can be anything from a pub that changes hands to that's a pub before, has all the staff, a pub directly after, carries on. So that would be an example for the first one. Bruce has already talked about the cleaning companies, but another common example is catering. So we have lots of inquiries about catering contracts which tend to change, and staff tend to change over. And one of the issues is whether the staff are wholly assigned or mainly assigned, and that can be a tricky issue as well, which I think Paul will deal with later. So just putting that in a bit more context for you. And as Bruce was saying, from a practical basis, because Bruce is obviously more of an advocate and I'm the paperwork girl, a good asset sale agreement or a good agreement is key. So, and that does generally, when you're going through an agreement, Bruce will talk about consultation in a minute, and employee liability information, but it is absolutely fundamental to get the terms in the agreement correct at the early stage. Sorry, Bruce.
And I suppose on that point, it's worth identifying that if, for example, it's a business that's in trouble, really needs to have the sale, or are very keen on the sale for whatever reason, the weight of, or the negotiating skill is perhaps with the transferee, but that's often not the case. There is an enormous skill in people in Marie's role and Marie negotiating excellent deals whereby there is a warranty or there is an indemnity which is suitable to both parties, as opposed to the weight of the transferee only taking over. That's
right. So apportionments of liabilities can be built into sale prices or staged payments or indemnities. But anyway, we'll move on from that. So,
okay, it's also worth noting that some transfers will be a business transfer and a service provision change. And to put the position of the supply of goods into a nutshell, TUPE applies to the supply of services as opposed to the supply of goods. Now, in regard to share sales, again, an absolute labyrinth opens up with this, but in short, for the purposes of an overview, TUPE doesn't apply to a transfer of shares, but it would apply to an asset transfer carried out as a precursor to a share sale or a transfer of the business or part of the business to the holding company following a share transfer. What I can say about that is, if you're in that sort of situation, definitely get specialist advice. Cross-border issues, again, terribly specialist, but TUPE, it's got to be borne in mind, it applies to a business transfer where the undertaking is situated in the United Kingdom immediately before the transfer, fairly obvious stuff. A service provision change where there's an organised grouping of employees situated in Great Britain immediately before the service provision change. And it applies even if the transfer is governed or effected by the law of a country or territory outside the UK, the service provision change is governed or effected by the law of a country or territory outside of Great Britain, and the affected employee's employment is governed by any such law. And lastly, the transfer of a business which may also be a service provision change involving or involves employees who ordinarily work outside of the UK. Territorial jurisdiction is again a massively complicated area. If you throw TUPE into the complicated area of territorial jurisdiction, get advice. Automatic transfer principle. So this is the ultimate question that comes along once you've got over the position that there is a transfer. When you've got the relevant transfer, the contracts of employment of those employees employed by the transfer, or that is the person taking over the business, the originating company selling, and assigned to the organised grouping of resources or employees that is subject to the relevant transfer, they automatically transfer to the transferee on their existing terms, with the exception of old age, invalidity and survivors' benefits under occupational pension schemes. Again, that's often a matter that's overlooked. There's a presumption that everything transfers. That's a rebuttable presumption on this basis. This principle applies to all employees who were employed in the grouping immediately before the transfer, or who would have been so employed if they had not been dismissed by reason of the transfer. So if the transfer or has made a number of people redundant, they take umbrage at that and say, well, it's an unfair dismissal or it's a transfer. In either event, somebody's liable, whether it's the transfer or the transferee. I don't care. I'm going to get my money from somewhere. That's an important factor. Okay, and of course, anybody who's dealt with TUPE is aware of the economic, technical, or organisational reason. Enormously complicated, even though I've put it into one sentence. That's an absolute labyrinth, and again, worth taking advice on, because it's not as cut and dry as, well, we've got a redundancy situation, we can dismiss this person. Simply not as simple as that.
In fact, Bruce, that leads into a question that we've got about what if you already have people in your business who do the same jobs as the people in the potential business where TUPE may apply. In other words, I suppose what we're saying is if you're taking over a business and you end up duplicating people in certain roles, what do you do then? Or can you not do anything? What do you have to say about that?
You treat them as normal employees in a redundancy situation.
Yeah, so you'd have to pull your existing staff and your new staff, and you'd have to carry out a fair redundancy process using a scoring mechanism, objective criteria, and it doesn't actually stop you from dismissing if you've got duplicated roles and staff in those roles, but you'd have to be seen to be doing it fairly. You wouldn't be able to say, well, actually we don't need you because you've transferred. That would present a problem for you.
And if you scratch the surface and you found out that from a redundancy exercise, albeit it was fair, on the face of it, if everybody had, for example, been made redundant who had been from the transfer, or it would look somewhat dubious. So you'd have to have an absolutely clean process. Maybe that the 5 people, or however many do, come from the transfer, but the clean process would be able to deal with that, presumably.
As long as you can justify your selection normally, you're okay. But again, you'd have to take some specific advice on that, and it certainly wouldn't be something you could, just say, well, we don't need you, please go. So
no, certainly don't do that.
Certainly not. Okay, so good to deal with that. Right.
Okay, moving on, the transferee does effectively step into the transferor's shoes with regard to the transferring employees. All of the rights, powers, duties and liabilities under or in connection with the transferring employee's contracts do pass to the transferee, and any acts or omissions of the transferor before the transfer are treated as having been done by the transferee. So this always strikes me as terribly unfair. You've got a position of sexual discrimination before you have any knowledge about it. You're informed of the potential of a tribunal or a tribunal coming up. You end up being liable for that sex discrimination if you're the transferee. So terribly dangerous, could be very expensive, embarrassing as well, and not your fault. But you accept the liability, you're brought into proceedings that you don't know anything about, and again, really important to get that information firsthand so that you can make a decision, if you're buying the company, to actually buy it, and of course to deal with it on an indemnity or warranty basis.
I think, just again to stop there, that one of the main issues with taking on liabilities is to make sure that you do obtain, if you are taking over a business, the relevant employee liability information, and at as an early stage as possible. I've acted for clients in the past who have made a half-baked attempt at, receiving a short list of people's names, addresses, start dates and salary, but they've not made relevant inquiries into any liabilities, ongoing tribunals, grievances, any disciplinary processes. And that kind of information, if you can get the information up front, is very helpful, as Bruce says. And one of the most common areas where there's a serious lack of information is when there's a service provision change and between tenders, and I think that's just an ongoing problem. It seems to be something that rumbles on and has been doing for years. So, but see how much information you can get up front is the key.
And next point, fairly brief, but employees who object to the transfer, in my experience, doesn't happen very often actually, but it's important to note that they do not become employees of the transferee, and what happens instead is that their contracts of employment terminate by operation of law on the transfer date, and there is no dismissal. So Marie and I have had this recently.
And in fact, it links into one of the questions, which is who has liability for the employee who objects to the transfer, which is the same question.
It is, absolutely. So on the basis that they don't transfer, the transferee doesn't, but it ends by operation of law. So a knee-jerk reaction might be to say, well, this looks like a redundancy. It's not. So what you've got to do is consider the actual position. Can you keep them on? Is there a role for them? But it's not a redundancy automatically, and certainly they stay with the transfer, or they just go away, perhaps with notice on the basis of some other substantial reason, dismissal, or simply, just as I've stated, by operation of law on the transfer date, they're not dismissed, they are just terminated. Okay?
Yes, that's the risk for the employee. So what you tend to get, and I have had one of these recently, is employees that say, well, I'm not moving, I like working here, I'm not leaving, but the reality is there is no role. They do transfer automatically. Does that put a liability on the employer who is transferring that service or business to pay them out? I would say not. But this needs to be explained very clearly to them, and I suppose, and/or unions. You need to get the unions involved if you've got a big issue. And obviously each case is fact sensitive, but I certainly wouldn't be rushing to make huge payments to people who don't want to transfer if they automatically transfer. So that's a common one.
Yeah.
Right.
Okay. So next stage in the process is you've established. So where we are right now is that we've established that there's a transfer. There is an automatic transfer. You've got them in, and what do you do with changing terms of employment? The transferee takes on the transferring employees on their existing terms of employment, and you can only make changes to their terms in limited circumstances. If you're outside of those limited circumstances, it's a strange position where even if you have their agreement, it's a void contractual clause. So again, a labyrinth appears, and a very difficult position to be in, where you have at one stage what seemed to be a binding contract, but it's void as a result of the TUPE regulation. So changes to terms of employment will be void if the sole or principal reason for the change is the transfer itself, unless the reason is for the variation is an economic, technical or organisational reason, and the reason for the variation is the transfer, but the terms of the contract permit the employer to make such a variation. Separate provisions apply when the terms being varied are incorporated by a collective agreement. There is protection against dismissal. So TUPE provides, in actual fact, it's an enhanced protection against dismissal over and above general unfair dismissal law for employees with at least the qualifying period of service. Now, again, this has cropped up in my practice where people are concerned that they consider it's an automatic unfair dismissal, and if you check the automatic unfair dismissal provisions or cases that lead to automatic unfair dismissal, there are a number of them where you don't need the qualifying period of 2 years. For TUPE, you do. So if they haven't got their 2 years, it's the same position as a normal one. And also on automatic unfair claims, often the statutory cap, once you get to the tribunal, is removed. For TUPE, it isn't. So dismissals will be automatically unfair, again, if the sole or principal reason for the dismissal is the transfer itself. But, and again, we have this very important provision of the economic, technical, or organisational reason coming into play. They will instead only be potentially unfair. So resignations in response to a repudiatory breach of contract or a substantial change in working conditions to the employee's material detriment are treated as deemed dismissals to which the enhanced protection against dismissal applies. Now, repudiatory breach of contract, that's easy is the wrong word, but it's we're all fairly familiar with that. The other part that people are not so familiar with is a substantial change. Now, there's been fairly recent case law on this where drivers of buses in London having to travel a further 6 miles, which is probably quite significant in central London, had suffered a substantial change because the bus company moved the depot. Now, that led to a successful claim for the claimant saying, I've suffered a substantial change. So it's a much, much lower standard than a fundamental breach. Very dangerous, actually, because it amounts to the same. Then moving on to obligations to inform and consult.
We've quite a few questions about that, which we might be better off dealing with at the end because we've got quite a few slides to go. So I have got your questions and I will put them to Bruce, or we'll get back to you on them, but we'll just finish the presentation.
Yeah, no problem
now.
at all.
Right.
Yeah, it's 9 o'clock
That's
already.
right.
Actually.
So
okay. All right. So both transferal and transfee for E, they must inform and, if appropriate, consult with a recognised trade union or elected employee representatives where you don't have a recognised union in relation to any of their own employees who may be affected by the transfer or any measures taken in connection with it. So significant is it's your own employees at this stage. Certain information must be provided to the representatives long enough before the transfer to enable the transfer or to consult with them about it. Now, although there will be a duty to inform on every TUPE transfer, the duty to consult only arises where an employer envisages taking measures in respect of affected employees. And the 2014 amendments are significant here, whereby since the end of July 2014, the amendment regulations allow micro-businesses with 10 or fewer employees to inform and consult affected employees directly in certain circumstances. So you can circumvent the employee representative and a recognised trade union route, which is often time-consuming, and where anything is time-consuming, it becomes costly.
And that might have looking at the question, that might have actually just answered one of the questions anyway.
Okay.
So,
all right.
come back to us if you want any more information.
Yeah, but if
that.
there's any more detail that you require, definitely do come back. A failure to comply with these obligations exposes the parties liable to pay compensation equivalent to up to 13 weeks uncapped pay. Now, 13 weeks may seem fairly insignificant. If you've got 100 employees still transferred, but saying that I haven't been consulted with, then it becomes much more significant. So again, fairly easy to comply with this element of the regulations, and fairly dangerous and definitely potentially very expensive if it's not complied with. The transfer or and transferee may, in certain circumstances, be held to be jointly and severally liable. Affected employees of the transfer or are only liable to obtain compensation from the transferee where the transfer or makes the transferee a party to the proceedings alleging the transferee's failure under Regulation 13.4. Now, what that means is that if you get to a tribunal situation and you're the respondent, you want to be taking advice on whether or not you make an application to the tribunal to bring in another party. Now, frankly, if I'm representing claimants, my advice is to bring in everybody at the beginning, and there'll be a preliminary hearing to deal with who should actually be within the proceedings. But if it's been missed, or there's an identification, for example, of there being indemnity or a warranty, or there's just ineptitude on the representative of the claimant's representation, then that's something that you need to bring in. And the tribunal have the right to do it on their own back in any event. Now, the 2014 amendment regulations amended the Trade Union and Labour Relations Consolidation Act 1992. That's referred to as TULACA, I think, often. Now, what that did was, or the purposes of it, were to enable the transferee to elect to consult representatives of affected employees, including those transferring before the transfer, provided that it notifies the transferor in writing and the transferor agrees. So in this scenario, the collective redundancy consultation requirements of Section 188 to Section 198, where if you've ever been involved in a collective redundancy will be very well known to you, and specifically Section 188 capital A. So they apply as if the transferee was already the employer of those transferring and as if they were employed at the same establishment. A transferee who elects to carry out pre-transfer consultation may at any time cancel its election. We then have the obligation to provide employee liability information. We've alluded to so how important this is. So the transferor must provide the transferee with certain information about the transferring employees referred to as the employee liability information, not less than 28 days before the relevant transfer takes place. Now, if the transferor fails to provide this information, then the transferee has a remedy under, and these are important regulations if you're in this circumstance and something else comes along later on in the day, Regulation 11 and 12 of TUPE. Now, again, I've recently dealt with a case where what we find is, and it's to do with schools turning into academies, and there's a transfer. There's details that were missed by the local authority, who are the transfer, or in these cases, to the next operating body, the transferee, for example, about equal pay claims, which are very, very common, even though they're running out a little bit. And also, this one happened to be about subsidence on the school property. So you can deal with that with this failure to provide the information referring to Regulations 11 and 12 of TUPE. Insolvent businesses, I've put it into a paragraph. It's a huge subject, but some of the fundamental TUPE employment protections are relaxed where the transferor is insolvent. It's by no means black and white. What it does is, the purpose is that it's designed to facilitate the rescue of failing businesses. And the extent of those modifications depends on the nature of the insolvency proceedings to which the transferor is subject. So what you've got to do is actually look at the proceedings, very complicated, an area of law all on their own, but ultimately what I say is you must get advice at this stage, or I'm strongly suggesting that you do. In general, though, more significant employment protections are removed where the transferor is subject to terminal insolvency proceedings which aim to liquidate the transferor's assets. What happens if TUPE doesn't apply? Well, if a business transfer from one employer to another, if there is a business transfer from one employer to another, but TUPE doesn't apply, then the employee's consent is required for their employment to transfer, and if the employee agrees to be transferred and the new owner of the business agrees to take them on, then their existing period of continuous employment will be preserved. And I put a further bullet point there, but it's actually a heading, and they are the key changes to TUPE made by the 2014 amendment regulations. And really, what that can act as, I don't mean to go through them, is that it's largely a repetition of what I've already said, but it's an aide-memoire to see just precisely how the 2014, in brief of course, have made amendments to the 2006 regulation.
Okay, so we've just picking up on one of the questions there then, Bruce, we've got a question relating to what if the company is in a different location and the employees don't want to transfer or relocate? Now, this used to be a bit of a thorny issue where, particularly from my perspective, I'd end up dealing with a number of settlement agreements on behalf of staff who say we're located in, say, Harrogate, we're being asked to transfer to a company in London. Everybody was in a sticky situation and a bit concerned, so I think companies took a view, well, look, we'll enter into a settlement agreement, and it ended up being a cost. This was something recognised in the changes, wasn't it? Where, I think it's on this slide. Have I come onto the right slide? Let me just have a look. There we go. So
changes in the location
that's right.
of the workforce
Sorry, I wasn't
following a transfer will be expressly included within the scope of the economic, technical, organisational reasons, and what that does is prevents genuine place of work redundancies from being automatically unfair.
That's
so I think
right.
that's the ultimate answer to that question.
That's right.
In brief, though, of course.
Of course, but it is now possible to include that as a potentially fair reason.
That's right,
if
yes.
there's a change in location, which in a lot of these cases, well, particularly the ones I've come across, that has been the main reason for employees not wanting to transfer,
Yes.
or not being capable of transferring roles due to family commitments, etc. So that probably answers your question.
Yeah.
We've got another private question which we can answer off air. Okay, so then we've got, there you go. So, I mean, that brings us to the end of Bruce's whistle-stop tour of TUPE. As I say, there is a handout, but the slides are quite